Hello, I'm Paul Kaufman. I'm a member of the Pennsylvania Bar Association's Mock Trial Executive Committee and one of the authors of the 2016 case. I'm coming to you now from CCP TV, the Emmy-nominated TV studio at the Community College of Philadelphia, and from the Community College of Philadelphia's Fox Rothschild Center for Law and Society. We thank both the center and CCP TV for hosting us here today. This video is intended to be an introduction to mock trial for new coaches, for new attorney coaches, and for people who are unfamiliar with the program. Our hope is to give you a sense of how Pennsylvania mock trial, and probably mock trials more generally, run. It is not going to tell you every rule, and it's not even going to tell you most of the rules. This is just designed to orient you to the basics of what we do. So, let's start at the beginning. What is mock trial? Mock trial is a simulation of a trial experience. In some ways, it's very much like a trial. There are attorneys, there are witnesses, there are objections, there are judges, and there are jurors, although in this case the jurors are there principally to give scores to the participants rather than to render a verdict on the merits. Now, they are trying a case in an extremely abbreviated period of time. Most trials in state or federal court go hours and hours, most often days, sometimes even weeks or months. We get a high school mock trial done in about 2.5 hours, from starting gavel to the end of the case. So everything is very compressed, and everything in the trial is associated with time limits. Now, the actual simulation is done by a group of not fewer than 6 people, so you have to have 6 members on your team, 3 to be attorneys, 3 to be witnesses. Depending on your regional rules, you may be permitted to have more than 3 attorneys, but there will only ever be the 3 witnesses. Now, a mock trial proceeds more or less as a real trial does, except that a mock trial exists in a closed universe. There are wonderful civics education competitions that are based on legal research, that are based on constitutional argumentation, and some of those competitions even have mock trial components. Pennsylvania's does not. Pennsylvania exists based on a case that is designed and written by people at the Pennsylvania Bar Association and associated with the Pennsylvania Bar Association. That case contains all of the witness statements you will need, all of the exhibits that you will need, all of the law and legal research that you will need. It's all contained in that packet. And indeed, there are various stipulations, that's agreements between the parties, and rules to prevent you from bringing in outside research or creating facts. It is in fact illegal to create a fact to make your case better. That's not the purpose of the competition. The purpose of the competition is to see how well you can try the facts that are given to you. So, you have 3 attorneys, you have 3 witnesses. Each side is required to call all 3 of the witnesses that are in the packet for it. Those witnesses will take the stand. They will be direct examined. That means that they will be asked questions by members of their own team on behalf of the case for whom they're testifying. So if it's the police officer in a criminal case, that person is almost certainly going to be called by the Commonwealth, by the prosecution, and asked questions on direct examination that help the prosecution. Those questions usually are open-ended. Who, why, what, where, when, how. Then comes cross-examination. And as everybody who's ever watched a law show on TV or a legal movie knows, cross-examination is when the other side gets to ask you questions. They don't have to ask open-ended questions, and in fact shouldn't. They ask very specific questions to either hurt the case of the other team or to undermine the witness's credibility by showing, for example, that the witness lied before or is lying now. The trial proceeds as a trial does in real court. After some preliminary matters are addressed, if there are any preliminary matters to address, opening statements happen. Now, there is some variation in states and federal courts about when opening statements happen, but in mock trial they always happen at the beginning. And in Pennsylvania mock trial, they are limited to 5 minutes. An opening statement is an opportunity to explain yourself, to go through what you think your case will show. Then, the prosecution or plaintiff, depending if it's a criminal or civil case, will call its first 3 witnesses. In order, they will be direct examined, cross-examined, and if the first side that called them has additional questions, you can do what's called a redirect examination. So if they gave a bad answer on cross-examination, and you feel like it's important for them to have the opportunity to explain what they meant, you can have them do that on redirect examination. And then you are open to re-cross-examination about that explanation. At the end of those 3 witnesses, the prosecution or plaintiff rests, and we move to the defense. The defense then calls its 3 witnesses. The same thing happens, only in reverse. The defense is doing the direct examination, and the cross-examination is done by the plaintiff or prosecution. Ultimately, after all 6 witnesses are concluded, so that's when the testimony ends, the evidence ends, and there is closing argument. Different states and the national competition do things differently. In Pennsylvania, we have the defendant close first. Defendant is given 5 minutes. Then the plaintiff or prosecution closes last, also given 5 minutes. There is no separate time for rebuttal in Pennsylvania. Now, a team also will typically have a timekeeper who's watching all of those time limits. In Pennsylvania, that means you've got 30 minutes to do all 6 of your examinations, all 3 of your directs and all 3 of your cross-examinations. However, there is one critical exception. The clock stops for objections. When the other side objects, that argument, which takes place constructively at sidebar, but actually in the hearing of everyone, that is not timed. Nor is it timed when you introduce evidence. In the case packet, you will see exhibits. This year we have 11. Some years we have slightly fewer. Some years we have slightly more. You are intended to use those documents, or at least some of those documents, to help make your case, to help substantiate what a witness is saying, to give evidence that the jury can examine. And you should use some of it. However, like everything in mock trial, we have not given you enough time to talk about everything the witnesses talk about, or to introduce every exhibit that's out there. You have to pick and choose what best fits the case you want to make. And that is one of the great challenges of mock trial. Broadly speaking, a team will have 6, 7, 8, sometimes more members. It will also have an attorney coach. That is an attorney, paralegal, or law student from your local community who is there to assist with the legal analysis that's necessary to do the case, help you to learn objections and things like that. All of that is done by the attorney coach. If you don't have an attorney coach, the Pennsylvania Bar Association is here to help you. Let us know. If you have an attorney coach and all of a sudden the attorney coach gets called away for a trial and you need more help, let us know. We will help you to try to find someone else who can do some work with the students. But the attorney coach is not the most important coach of a mock trial team. That role belongs to the teacher. The teacher is there to help run practices, to bring the students together, to make certain that the school is advised and informed and all the proper paperwork is done and everything else. The teacher coach is the heart and soul of the mock trial team. Now let's talk very briefly about the structure of the competition. It varies depending on where you are in the state. So please, check your local listings. Broadly speaking, the Commonwealth of Pennsylvania is divided into regions. There are approximately 10 regions. Some years we might have one or two fewer, some years we may have 1 or 2 more. But right now we have 10. Those 10 regions are generally, but not universally, broken down into districts. So you will compete first within your district. A district is a geographic area that is designed ideally to be small enough that you can reach the site of your competition without great travel. If you are successful in your district, which may mean winning the district or may mean finishing second, depending on the way that your region is structured, you will then move on to the regional championships. The regional championships will bring together teams from districts within the region to compete again. You may have to travel a little bit farther to get to a regional championship. If you are successful at the regional championship, which in most cases means winning it, but in a few cases might mean finishing second, you earn the right to go to Harrisburg. There are 14 teams that will be competing in Harrisburg this year for our state championship. The best of the best. We have about 330 teams that register Commonwealth-wide for this competition, and only 14 will make it to Harrisburg. And unfortunately, only one of those will make it to nationals. The national championships are held in a different location each year. For 2016, they will be in Idaho, in the city of Boise. And we hope that every one of you is competing to try to make it to Boise. But only one representative of Pennsylvania ultimately will be. But every one of the 330 teams in the state will have the opportunity to learn about the law, to gain confidence with public speaking, and we hope to come to a better understanding of how our civil justice system works. Thank you for listening, and we look forward to seeing you all very soon.